Hello, this is Tim Borchers from Borchers Trust Law, and we're presenting today on the topic of post-2024 election on the effect of estate planning, especially estate taxes, for estates in the range of $2 million to $10 million. We will also be doing a workshop for $10 million and up on an event in a couple of weeks, which will be December 18, and you can also pick up on that if you wish to. So welcome today. If you have questions, feel free to put them in the chat, and we will get started with our presentation. Our credentials here, we've been doing this for quite a while, and therefore hope we have enough information for you to have confidence in our abilities to work with you on these questions. If you're clients of ours, welcome. If you're guests, it's very nice to have you with us as well today. I have a couple of disclaimers. The first one is typical, which is that don't rely on anything you hear today for actual legal advice. You need to have one-on-one tax and legal counsel with us or with other advisors, as the case may be. Don't rely on this information. I'm also giving a little unusual disclaimer, if you will, because I'm assuming here that you wish to leave as much wealth as possible to your heirs by saving taxes. Why do you want to do that? Well, that's for you to decide. What I hear mostly from clients is that they believe their children and grandchildren's lives will be better with more wealth. You should probably challenge that assumption. More wealth used for good purposes, great. However, wealth used for bad purposes or not the purposes that you would prefer, you might as well give that extra wealth to charities rather than let it be used for bad purposes. So maybe pay charities instead of the government for taxes, maybe give less to your kids if that's the case. But in all seriousness, what you want to do is, of course, leave a good estate plan that's going to encourage good uses of that wealth, and that's what effective estate planning is all about. So sign up for that with us or with somebody to give yourselves a good estate plan. So what is the impact of an all-Republican federal government for estate tax planning in 2025 and 2026? So the first thing to know is that the tax law that was passed in 2017, which is known as the Tax Cuts and Jobs Act, which went into effect January of 2018, doubled the federal exemption from the amount in effect at that time, and it's been since adjusted for inflation. However, that is set to expire. That law will expire because of a provision in federal law that says you have to have a balanced budget at some point, and so there was an expiration date. Guess when that is? December 31, 2025. So it's possible that that law, with a big exemption of about 14 million, could cut in half to only 7 million by the end of 2025. The other thing to know is that even though Republicans would love to extend that law to go even further, it's possible that the estate and gift tax law is going to be a negotiable item here because it only affects a tiny, tiny portion of the population. Today, it's only about 1%, sorry, 1/10 of 1% of the population that even files one of these returns. And if the law was allowed to expire, it might be as high as 1/2 of 1%. So it's still a very small portion of the population that this tax affects. And yet it does produce pretty substantial income over time. And therefore, it's not out of the question that they may extend other aspects of the TCJA, but not extend the estate and gift tax exemption. Income tax provisions are also potentially relevant for estate planning, and a few of those are relevant under the Tax Cut and Jobs Act, but mostly we're talking about estate planning implications. Okay, so under the current regime from 2018 through 2025, the estate tax exemption is doubled from what it would be under the law otherwise in effect. And so In 2018, it went to 11 million, 11.2. For individuals, for couples, they were able to double that by using what's called portability, up to $22 million. But index for inflation, these numbers are now going to be over almost $14 million. So 13,991, I think, is the number. Anyway, call it $14 million for individuals and almost $28 million for married couples who can use portability. And portability basically is the ability to piggyback your exemptions. If you have a $14 million exemption, you die, and you only used 2,000 of your exemption, there's still going to be 12, you only used, 2 million of your exemption. Your spouse will still have another 12 million out of the 14 million, 12 million to use on top of his or her additional 14 million. So they'd have 14 plus 12 again, so you get up to that total of 28 million. So that's how that works. But if you remarry, if the second spouse, the surviving spouse remarries, then you lose that exemption. Now, for planning in Massachusetts, there's no direct impact that one would draw a line from the federal to the state with a Republican administration. There's really no direct correlation there. So we're really on our own here in Massachusetts. In the Northeast, Connecticut, Maine, Massachusetts, New York, Rhode Island, and Vermont all have estate taxes. New Jersey happens to have an inheritance tax, which only affects a tiny portion, and New Hampshire has no estate or inheritance tax. Among these states, Rhode Island is currently the worst in terms of its exemption, but Massachusetts isn't far behind at $2 million exemption. By the way, you can find out more on these exemptions for the Northeast states on our website if you look for the estate planning guide, the Northeast Estate Planning Guide. And that will tell you more about both estate and income tax actually for the New England and Northeast states. The estate tax and gift tax in Massachusetts. So this was doubled effective in 2023 from only $1 million exemption up to a $2 million amount. So now if you have a $1.9 million estate, you no longer, or your heirs will no longer pay estate taxes. If you had a $2.1 million estate, then they're going to pay tax on that extra $100,000 at roughly 8%. So on a $100,000 taxable amount, your heirs would pay about $8,000. Not a terrible tax as taxes go. Naturally, it gets worse the higher you raise the amount of your estate, and it caps out at 16%. The Massachusetts tax will cap out at 16% at around a $9 million estate. The second thing to know about Massachusetts is that there's no portability. So you can't say, I'll piggyback my exemption on my spouse's exemption, and together we'll have a $4 million break from the tax. That's not the case. So the next bullet follows in line with that. You either use that exemption or you lose it, but you can also protect the exemption. So use it or lose it or protect it. And we'll tell you how to protect it here in this seminar. There's also no indexing for inflation in Massachusetts like there is on the federal exemption, which does happen, has happened every year. We've had inflation every year since 2017. So the exemption has gone up, but Massachusetts is stuck at the $2 million amount until further revision by the legislature. But if you recall, it was stuck at $1 million for nearly 18 years. So I'm not holding my breath for when the 2 million might get raised again. Massachusetts has no gift tax. So if you make large gifts to the next generation, there's not going to be any assessment by the state of Massachusetts. And at the moment, this may be only a loophole, but at least the law right now does not require that we claw back any large gifts onto the Massachusetts return. In other words, let's say you, before dying, gave away $1 million. Prior to the 2023 revisions in the Massachusetts law, we would have had to have added that $1 million that you gave away, if you gave it away in a big lump sum like that, back into your estate when you died. So it's like you were $1 million richer. Right now, that's been eliminated. So what you're going to learn about that is that it would appear that you can make large gifts prior to your passing without it negatively impacting, and in fact positively impacting, your estate. I don't think we've seen the last of that, but that's where the law stands right now, and we have that on very good information, including from the Department of Revenue. Next, Massachusetts has codified right in the law the exemption of out-of-state real estate. So it's now a favorable thing to keep owning property anywhere else, foreign countries included, because that property, that second home, will not be included in your estate. So I'm not telling you don't buy a second home in the Berkshires or Cape Cod, instead go to New Hampshire, but wouldn't be a bad idea. So consider second homes out of state. Could be other property as well. It doesn't have to be a home. It could be investment property. And lastly, Massachusetts got rid of the dreaded cliff. So some of you will remember that if your estate exceeded the exemption amount, so it used to be $1 million, right? So if you went over $1 million in your estate, you die, then you were kicked back down to basically starting over at about $60,000, and the tax was computed on your estate for that whole range, and you ended up paying tax even though you might have been over the $1 million by even a few pennies. All right, so what is your safety zone? From the federal estate tax, your safety zone, if you're in the $2 to $7 million range, I would say as a single person, you can be reasonably confident your estate will have no federal estate tax to pay, but you will have Massachusetts tax. Now, why did I use 7 million if I just told you that the federal exemption is 14? But remember, that may expire, and we're going to be dropping back down to 1/2 of that amount. That's what is scheduled to happen in 2025. But if we're likely to have an extension of that under the Republican domination of the three branches of government, the legislature and the president, let's put it that way, in government, maybe we get through at least 2026. So I'm saying, look, if you're in that range, 20 through 2026, I don't think it's likely there's going to be a federal tax on your estate for sure. And the Massachusetts tax is really all you're going to be dealing with. If you're married, on the other hand, and you're between 2 million and 14 million, you will pay mass tax. But again, not the federal tax on the same rationale that we expect the tax exemption at the higher amount will be extended. But even if it's not extended, and you are at the 14 as a couple or 7 as an individual, it's very unlikely that you're going to have to pay estate taxes at this point. If you exceed the 7 million and the estate tax higher exemption is allowed to expire, if you've exceeded the 7 million as an individual, you will start to pay federal estate tax. So you have to be vigilant and look out for these limits. But I think it's fair to say, again, I'm repeating myself, but I think it's fair to say, as a single person, up to 7 million, married up to 14 million, it's not likely you're going to have to pay federal estate taxes for the next couple of years. So do stay vigilant. Estates, remember, assets double at 5% growth every 15 years. So if you have 15 years to go, your estate can likely double in that time at 5% per year growth. If you have 30 years left, it'll double again. So if you happen to have a $7 million estate, by the time you pass, it may have doubled up to 14 million, and then it could double again in another 15 years. Estates double every 10 years when growth occurs at 7% a year. So nobody ever thinks they're going to be doubling their wealth. But if you look back to where you were 10 years ago, you might be able to do a little reality check on this and see that that's the case. Now, next, pay attention to the tax laws themselves. Okay, so how do you do that? Well, you read, you always attend our seminars and webinars. You come in for your reviews, keep your appointments with our firm if you're on our trust support program. If you're not, then you might want to consider joining that program. Otherwise, review anyway, even if you're not on the program. Minimize Massachusetts estate taxes, which will cap out at 16%. An unprotected $6 million estate would face a tax of roughly almost $400,000 as an example. Now take that same estate and say that it's doubled in, whether you double in 10 or double in 15 years, and that $6 million estate is a $12 million estate, then that tax is probably going to be close to $1 million, very close to $1 million of taxes. So if you want to pass another $1 million, or in this written example here, another $390,000 to your heirs because you think they can do some good with it, then you need to be proactive. You need to take care of business on these matters. So how do you do this? What should you do? You definitely need to consider using trusts, both revocable and irrevocable. And let's talk more about that in a minute. Just to repeat, just because we're going to emphasize the Massachusetts estate tax here in our discussion, the estate tax in Massachusetts, exemption is $2 million. Either use it, lose it, or protect it. Massachusetts has no gift tax, so let's try to take advantage of that. And Massachusetts has codified the exemption of out-of-state real estate. Now, you're a single person and you have a $6 million estate in Massachusetts. Nothing you can do, right? Well, I would say not so fast. All right, let's look at this. So since Massachusetts does not have a gift tax and is not at this time clawing back large gifts, our suggestion would be to fund an irrevocable gift trust. So let's break that down. So you're going to have to create the trust in the first place. So you're going to create an irrevocable trust. You understand that that's a trust that you can't take back. You might still have some control, but whatever you put in, you can't take back. All right, that's a given. So you got to think, well, I've got $6 million. I don't really need to spend the whole $6 million. I could part with some of that. Consider funding a trust that doubles as a gift. It's a gift trust. We also have another term for it in our practice. We call those inheritance trusts. And when we set them up during lifetime, they become lifetime inheritance trusts. So consider funding the trusts rather aggressively. What does it mean to aggressively fund that trust? It means that you're going to exceed your annual exclusion from gift tax. All right, what's that? That has been adjusted for inflation over the years. So if you're still remembering that for a long time, we had a $10,000 a year exemption from having to file a gift tax return. In other words, you could give anybody $10,000 and not have to file a return for it. Well, that's been indexed for inflation so that in 24, it was $18,000 per person that you give to, and in 2025, it's going up to $19,000. It is at $19,000 as of 2025. So you can give any person $19,000 and not even have to file a gift tax return. I'm not talking about necessarily just giving away 19,000 here and 19,000 there. I'm talking about putting that money into a trust so that it doesn't actually go into the hands of anybody quite yet. So we'll talk about that a little bit more in the following slides here. My next point is that Massachusetts has codified this exemption of out-of-state real estate. So own real estate in another state if you want to find another way to preserve wealth. The real estate isn't going to go anywhere. It's just as good as money in the stock market, many would say. Maybe that's a great strategy for you if you don't mind being a second homeowner or an investment property owner. Thirdly, life insurance is still a terrific tool to use in passing wealth without estate taxes. So at this point in your life, I suggest you think of life insurance as a form of investment. It's no longer about replacing your income so that your kids and your spouse will have food on the table. It's about investing in a way that's going to be tax-free. So you can invest in life insurance, do it inside of an irrevocable trust. That way, all the premiums that you pay in are gift tax-free because they're going to be small enough that they're under the gift tax exclusion. And all the proceeds are estate tax-free and income tax-free. So you might have known that already. Life insurance is always income tax-free, has been forever. And it's estate tax-free if and only if you put it inside the irrevocable trust. So we're going to talk a little bit more about these. These are just general ideas for you to consider at this point. All right, so again, we've got this $2 million exemption for individuals, and there's no portability. And you're married now. Again, we can use, lose, or protect. So we have a great opportunity in the case of married couples to protect the $2 million exemption when the first spouse dies. Again, protect the $2 million exemption when the first spouse dies. If you don't protect it, then that's when you lose it. It just gets melded into the assets of the surviving spouse, and it's no longer a preserved exemption. It's no longer going to bypass. It's not going to bypass the second estate. You've lost the exemption. You've let it merge in with the surviving spouse's assets. That's a bad idea when you are in this category of wealth in the $2 to $10 million range. By putting that $2 million aside, it can save in the top tax bracket of 16%. It can save as much as $320,000 of taxes right off the bat, and possibly more with the growth inside the trust. And what I'm talking about there is that the first spouse dies, we shelter $2 million. By the time the second spouse dies 10 years later, the money is doubled to $4 million. Well, the $4 million, had that been included in the estate, might have been taxed as high as at $640,000. So the savings can increase depending the longer the surviving spouse lives beyond the death of the first spouse. So this is tried and true. Anybody who has a protection plan with our firm, that's what we call it, a protection plan, already will have this in place. But it never does any harm to double check with us, and we can review the language together, especially in trust support review meetings. Next bullet item, irrevocable gift or lifetime inheritance trust. You can put aside money that way, securities, business interests, or real estate. So it's easy to imagine how you might put cash into the gift trust. So you're somebody who likes to carry a lot of cash. You don't like the stock market for everything that you own. It's easy to think of putting cash over into the gift trust. It's easy to think of putting securities into the gift trust. Percentages of your business. If you're a business owner and you say, well, I want to move $500,000 of wealth into an inheritance trust for my kids. We just need to do an appraisal of the business. We could do it with real estate as well, do an appraisal of the real estate, and then move a percentage of that business or real estate into the trust, whether that be a percentage of an LLC or a number of shares of stock in a corporation. So you can move that money into that trust. Now, once you've moved it in there, again, we're expecting that money to grow. I modeled out a plan this week for clients where they had approximately a $7 million estate, and we expect their estate to double in their lifetime. And they would like to pass as much wealth as possible to their children and grandchildren. And so we've devised a plan whereby they create 4 lifetime inheritance trusts for their 4 children, and they're going to move roughly $500,000 a year into those trusts. Meanwhile, the rest of their wealth can continue to grow. They're living within their means. They definitely make more than they spend at this point on their $7 million estate. And the result of that, we can calculate. We have software. We can look at this very specifically if you want to, and just see how convincing those savings will be over the years. Married couple can do irrevocable life insurance trusts as well. And this time they can do not insurance on one person, but they can do what's called a second to die. So if you're in reasonably good health, you can insure your lives. Naturally, the older you are, the more expensive it is, but you have to think of it as an investment. So you're investing in tax-free benefits. Remember, your goal is to pass more wealth to the next generation. And a very positive way to do that is with life insurance. And people often recoil at buying life insurance after age 60 or 70, but you really must consider that as a possible option if you are in this category of assets, because well, who would you rather pay? The insurance company, and then your children get income and estate tax-free benefits, or would you rather pay the state of Massachusetts taxes when you die? And then out-of-state real estate, property in an estate tax-free state is the way to go. So put that, buy property in practically any other state. We have to do that carefully. I say practically any other state because, if you go to a state like New York that has, I believe, a $6 million exemption from estate tax, don't quote me on that, they're not going to bother you if you have a $1 million property because you're well under their $6 million, but you got it out of Massachusetts. And there's a particular way we want you to hold title to that. So you have to talk to us about how to hold title to out-of-state property. Another great technique, and this is an income tax technique, is to do Roth conversions. Now, everybody knows about Roth conversions. And what gives you extra leverage here is that not only do you have to pay the income tax on the conversion, but remember that your heirs are going to get to stretch out the payment from the Roth for 10 years after you're gone. It's all income tax free when they get it, because that's what Roth IRAs are. And you get an additional boost for that savings. They're not only saving the income tax, but they're also saving the estate tax on the amount that you would have included in your estate had you held on to the traditional IRA until you died. So if you've reduced the size of your estate by paying taxes on it in your lifetime, your heirs are getting less in dollar amount, but more in after-tax benefits from that. Now, it does depend on your income tax bracket. If you're in the top tax bracket, you need to look very closely before you just jump into doing this. But if you're paying taxes in the 20 to 25% range for income tax, if that's your bracket, you definitely should give this consideration. The other thing is that if one of you in a couple, if one of you dies, then the surviving spouse is almost always going to be in a higher tax bracket, because your income is still going to be relatively the same as what it was when you were both living in most cases. And that's going to boost you as an individual into a higher tax bracket, which is going to make the conversion even less attractive. So it's best to do these conversions if you're married while you're both with us. Now, lastly, I would say take those irrevocable gift trusts that you've just created to New Hampshire. I'm not just talking about taking them on vacation with you in your backpack. I mean, literally, we're going to move that trust to be housed with a trustee in New Hampshire. And guess what? We've established a trust company that can serve in the state of New Hampshire. It's a trust service company, so we administer the trusts there, and we use a trustee that's located in that state. What's that going to do for us? I think that in order for this to be meaningful, you should probably have a trust of at least a couple $1,000,000 or more, because then the administrative cost will be more than paid for by the tax break that you're getting. So let's delve into these two options a little bit further. So the traditional IRA to Roth conversion. So let's say you're in a 25% tax bracket on a $100,000 Roth conversion. That's going to cost you $25,000 in federal taxes, isn't it? You may be paying 5% Massachusetts tax on top of that. We'll keep this simple, talk about the federal rates. So you would net $75,000 on that. If you were to die in 10 years after 7% growth annually, you're investing relatively aggressively in your Roth IRA. You're not taking any money out. The sum would double, and it'll be equal to $150,000. There's no required minimum distributions when you have a Roth IRA. So even if you're 73 or older, you don't have to take anything out of a Roth IRA. Now, continuing, your estate tax saves, let's say 15% in estate tax. Your estate saves 15% in estate tax on the $25,000, all right, which would have doubled had you left it invested inside of a traditional IRA. It would have doubled up to $50,000, and the 15% tax on that would have been $7,500. Okay, so there's $7,500 in taxes saved. That's not nothing. Then again, your heirs have 10 more years to take out the Roth IRA. There are formulas now that they have to follow for that, but it's usually going to be that they only have to take a little bit out every year. They pay 0% income tax no matter whatever their tax bracket is. And if the money doubles again in 10 years, the earnings on what ends up in the Roth might be doubled again from the 150 in my example to say $300,000. And that's going to pass income tax free, plus the estate tax saved of $7,500. So doing the math, I haven't given you an exact bottom line number here. That you have to do one-on-one with a tax planner or with us, and see whether that savings is worthwhile. But remember, what are you doing? You're reducing the size of your estate. You're paying the income tax instead of your kids. What if you have just a small traditional IRA? Say, like a lot of clients, they get to the point where they're 90 years old and they only have 100 grand left in their IRA. I would say just take it all out, pay the tax on it. Give the money away to your kids if you want to. But by taking it all out, paying the tax on it, a lot of the people in that age category and wealth and income category are in a lower tax bracket than their kids. So why not the parents pay the tax, reduce the size of their estate, gift away the net proceeds, assuming that they don't need the money, obviously, to live on. So these are great techniques, always should be examined. And we're also assuming that you're paying the taxes in these assumptions here with money other than from the IRA. If you use the IRA money to pay the taxes on the Roth conversion, it's far less attractive. All right, more on that New Hampshire idea. All right, so let's say that you create the trust, you move the gift and inheritance or inheritance trust to the granted state. Let's say it's a $4 million trust earning 7%. It's taxed in the Massachusetts bracket at 5% and possibly 9% if you're subject to the millionaire's tax, which is an extra 4%, at least to the amounts over $1 million. Avoiding the 5% is at a 7% earnings of $280,000 at 5%. That's $14,000 in saving in the first year, minus service charges to keep this system running of roughly $5 grand. netting $11,000 of savings. If you're avoiding the 9%, then your savings is obviously even bigger, calculated at $20,000 in this case. Now multiply that savings over several years, and you've got yourself another great formula for passing more wealth because you're saving taxes. If you happen to have collectibles, a few people have things that are considered collectibles. If you were to sell those, the Massachusetts income tax on selling those is 12%. So it's also a very large savings. And there's other advantages to trusts in New Hampshire as well, other protection of the trust that we can take advantage of. So in the Bay State, whether you're single, whether you're married, using lifetime gifts makes a lot of sense. The annual exclusion, as we said, is $19,000 that you can give per person in the year 2025. And if you're married, you can double that. So that brings you up to $38,000 that you can give away per person. If you want to give those gifts directly, many people do. They love to see their family make good use of that kind of money. Then go ahead and do that. But I want to open your eyes to really looking beyond these annual exclusion gifts. Again, if you're in this $2 to $10 million range, it's really unlikely that you're going to be paying federal estate taxes. Then why are we worried at all about making large gifts for which we have to file a gift tax return? So a big deal. You file a gift tax return, but you've gotten a lot more wealth out of your name. You could, instead of dying with a $5, $6, $10 million estate, you could whittle that down to a much more manageable number. And again, saving as much as 16% on those assets every time you do that. So instead of direct gifts, I would have you put it into trusts. So we use the Crummy Power trusts. Those are the gift trusts, the inheritance trusts, the insurance trusts. These all work great. What the Crummy Power is doing is giving anybody that's a beneficiary of the trust 30 days to withdraw the gift that you put in. I just finished doing this with life insurance proceeds myself for the year, as I've been doing for many, many years. I'm paying not life insurance premiums directly to my insurance company. I pay it to the trust, and then the trust pays the premium. I give notice to my 3 oldest children that they have the right to withdraw the funds. One of them who will go unnamed, but said, geez, I could use that money right now, actually asked me this year, so what does that really mean, Dad? Can I really take that money? And I said, yes, you can, but you won't be getting $1 million of life insurance when I die, to which he said, okay, never mind. But this is a good strategy. It works year in and year out. So you can also include, little did you know, you can include your grandchildren as recipients as well. They can also be recipients of these 30-day gifts. So you can take children and grandchildren, and you may end up with several people that you can just use the gifts into the trust, of which $19,000 per person will be excluded from having to either file a gift tax return and certainly to pay any gift tax. But again, if you haven't given away as an individual, right now it's $14 million. If you haven't given away $14 million in your lifetime, and not too many of you have, then you're not going to pay any gift tax anyway. And I think people need to be more and more aggressive. The higher these exemptions are on the federal level and the stiffer the Massachusetts tax, the more it makes sense to make these very large gifts and to do them in trust. If you include grandchildren, then the gifts to the grandchildren lapse after 30 days. And at the end of the day, the wealth is passed only to your own children. So you included the grandchildren only in case your children died. And the gifts to them while you're alive lapse after 30 days. So when you die, it's really still just your own children that would inherit under these trusts. So it's a very, very safe proceeding or procedure. All right, so just to review a few things, Massachusetts, we got this $2 million exemption. There's no portability. use it, lose it, or protect it. There's no indexing for inflation. Massachusetts has no gift tax, so you can make larger gifts and do it with a lot of confidence. Out-of-state property is exempt, and we got rid of the cliff. So we have some significant advantages that we can take advantage of in Massachusetts. So at this point, I'm going to leave this screen up for a minute. Look, if you're a trust support client, let us know your questions or concerns. By the way, I didn't say in the beginning, I should have, that if you have questions, put them in the chat. You have time to do that right now. Put them in the chat box there, and I'll turn to those in just a couple of minutes. If you're a trust support client and something that we've talked about here has stirred your curiosity, go ahead and email us, email your attorney that you deal with mostly, Mark at, or Tim at, Deborah at, Mackenzie at Borchers Law. And then we'll set up time to talk about your concern. And if you're not a client of our support program, then your action for today is really to make an appointment. Make an appointment to review your plan to make sure that you are transferring the most wealth the way you want to. So call or email us to do that. The next webinar we're offering is for larger estates. So some of you might even be in that category as well. Feel free to tune in to that one on Wednesday, December 18, starting a little earlier at 2 p.m. And there we're going to talk about some advanced techniques that are fun to apply to save. Now we're thinking about the 40% federal estate tax, trying to save 40%, a very big deal, plus the Massachusetts savings. Reach out to us, info@Borchers Law, call us, go to our website, and we will do our best to work with you to make sure that you're passing the most wealth the way you want to. So I'm going to now stop the sharing of my screen, go back to looking for your questions. And we have a question in the chat so far that says, are there any sophisticated tools for clients in this range of 2 to 10 million, and why aren't you recommending them? So there are some great tools. I love talking about them, but because the marginal tax bracket for you may only be 10%, 12, at most 16%, is it worth the administrative work, the additional fees and so forth of setting up those techniques? But I will be talking about those on the 18th. So tune in then. We're going to talk about those because they're the savings can be even more significant. What would the tax on a $5 million estate be in Massachusetts? And I happen to have written down an answer to this because I anticipated the question perfectly. If a 70-year-old was to receive a 5% return on their $5 million estate, so they're making 5% on their $5 million estate, and they live for 15 years, we're going to have an estate of $15 million. I'm not sure that makes sense now that I think about it. Oh, that's because I'm assuming that they could double twice. Sorry. So they're going to save a lot of money. Let's put it. They're going to have a big tax, and they're going to end up saving a lot of money. If they had a $15 million estate by the year 2042, which is their life expectancy, if they're 70 years old, your life expectancy would be to live to 2042. Mark it down, put it on your calendar. The tax on that estate at that point in Massachusetts would be $1.8 million. If you had only $5 million today and you live to life expectancy and you make money on that every year, At the rate I'm talking about, you could have as big a tax bill as $1.8 million to have to pay. So it makes sense to try to plan to avoid that and pass as much of your wealth as you can for the uses that you want it to be put to. The same question with regarding a 90-year-old. If somebody had a $5 million estate and they're 90 years old, again, living to life expectancy, their estate tax at life expectancy, which would take them to 2030, would be about $800,000. $800,000 is the check that you'd have to write to the Commonwealth of Massachusetts 9 months after death if you were 90 years old today with $5 million living to life expectancy. Now, it's a little bit better if you're married, don't forget, if you do planning with us with trusts, if you're married. When is a good time? Last question I think we have time for is, when is a good time to start making large gifts? And I would say that any time that you feel financially comfortable using good projections, that you can put aside 50, 100, 200 or even more $1,000 a year. You could start as young as your 70s, certainly by 75. You might have 15 years to whittle that down. If you happen to die young, maybe you've got some life insurance that's part of your quiver of weapons to fight off this tax liability. And that life insurance would help pay the tax if you didn't make it to the full maturity of giving your money largely away above the $4 million mark. There is one other question. Can I or an adult child take on the administration of their own irrevocable trust? Yes, you do not have to have any third party be the trustee. You can administer the irrevocable trust. You can't administer your own irrevocable trust if you're doing it for tax purposes. In other words, you can't be the trustee of your own irrevocable trust. So you do need a competent, responsible adult child, or you can also use our trust company, and we can be a directed trustee, which means we don't have full responsibilities. We are directed. You would direct the investments. You would direct the distributions, if any, and we would just act as the administrator. And that's a role that we can play as a professional trustee as well. So those are the topics for today. I hope you've got something out of this. You can also find this presentation. It'll be linked in our next newsletter. At some point, it may be on our YouTube channel, etc. So you can find this. You can share it with friends and relatives. Meanwhile, happy holidays and happy new year. Bye now.